January session of the Iowa Court of Appeals. This panel is set to hear two cases in the 10:30 session, and the first of those is 24-1942, in re the Estate of Kahler. Is that correct? Kahler, thank you, in re Estate of Kahler. For the appellant, we have Mr. Tyler Smith, and for the arguing for the attorney for the appellees is Brian Young. So, Mr. Smith, whenever you're ready.
May it please the court, counsel. Good morning. Before us is a case about Iowa's longstanding rule that wills are to be construed and interpreted in order to give effect to every clause within the will through harmonization, with repugnancy only a last resort when there are irreconcilably conflicting provisions. Here the district court correctly found there was a typographical error in the clause at issue, Article 2, Section B, correcting a township number, I believe, but erred when it found that clause to be repugnant with 2 or 3, depending on how you read it, other clauses here. So the language is that Art Kahler, the decedent, bequeathed to the Burmeisters, Cindy Burmeister being my client, under Article 2, Section B, specifically described through a legal description parcel in Section 10, Township 92, corrected 97, Range 29, but also all his property in that same section, Township and Range.
Does the record show how many, at the time the will was created in 2012, how many acres Mr. Kahler owned in Section 10? Was it more than the 80 and 30 that was devised in the other paragraphs?
Your Honor, I think the record only shows the 80 and the 30 in that regard, and we know this through the bequests and the will in reference to Exhibit 109. So,
just to clarify what you mean by that, does that mean it shows that he only owned the 80 and the 30, or that we don't know whether he owned more than the 80 and the 30?
what is
Which of those two options is correct? Okay, so we don't know if there is some extra beyond that could have been covered by this other language.
pulled out? Yes, I would agree with that, but I think there's 99% confidence that this was the land that he had because the parcel at issue was an after-acquired parcel. I don't think there's any dispute on that. What is also undisputed, though, is that Art Kahler wanted the Burmeisters to receive any additional land within that section, Township and Range. Otherwise, that clause would have absolutely no purpose in being there. Now, he gave very specifically described through legal descriptions land to the Kolstad family and to the other Kahler family and to the Burmeister family. And here we have a very standard approach to where we have a general bequest of a generally described area of property, which is carved out by the specific bequests of A, B, and D under Article 2.
Even without the after-acquired property, there would be a repugnancy between the general division or the sort of mini residual clause in B and A and D, wouldn't there?
No, I would disagree with that. There would be, because we still have the general and the specific, and when there's a general bequest, it yields to a more specific bequest. The case law teaches that only...
Understanding how that general request to the Burmeisters wouldn't have just eliminated the specific specific devices in A and D.
Because we have to first attempt to harmonize all three provisions together. And that can be done by understanding that what Art Kahler wanted was for 3 families to have 3 very specific pieces of property within that section, Township, and Range, and any other property within that general section, Township, and Range to go to the Burmeisters. And that's a harmonization principle there. And yes?
Back to the earlier questions, but what other property within that section and township did he own at the time of the will?
Know of.
Okay.
Logically then apply to after acquired property. It's undisputed that this would be after acquired property, the parcel at issue, this additional 40 acres. So it fits squarely within this contemplation if you're Art Kahler In fact, looking at, Exhibit 109, we see that this after acquired property is in fact contiguous to the two of the other parcels bequeathed. It's reasonable for a farmer like Art Kahler to have contemplated or had conversations about acquiring property or understood that he had plans or an in on acquiring additional property within that section, township, and range. Counsel. Yes.
I'm sorry.
Topic, so.
Is there any evidence of that intent?
No, there's not specific evidence, and I think that's because we're sticking to the four corners of the will, but I believe harmonization allows some provision for what the testator's overall intent was and thinking was. And here was clearly to provide specific parcels to certain individuals, but that we strive to give meaning under our case law to that additional all my land in that section, township, and range.
Counsel, I want to back you up a little bit in the analysis, sort of on the correcting the language, and I'm struggling a little bit with that part of it. So, as I understand it, ordinarily we can't look outside the four corners, the extrinsic evidence, at all. And if we didn't do that, if we stuck with the language, this provision wouldn't do anything. I mean, it doesn't describe any legal piece of property. And, we can look at extrinsic evidence to conclude that there must be something wrong with this language, because obviously there is no Township 92, Range 29 in Kossuth County. But I'm not sure, once we open that door, then the question is, well, what did this mean? What's the extrinsic evidence show us? But it seems to me like there's multiple options, right? Like there is a Township 92, Range 29 in another county, in Humboldt County. There is, a Township 97 in Kossuth County. I mean, both of those are possibilities. And the third possibility would be that this was an extraneous line that shouldn't have been there at all, that it got, in the course of editing things, it was left in there. So how do we choose between those three options? And what extrinsic evidence or evidence within the will is there to help us decide? And it seems to me you kind of want us to look at that one piece, like, well, since it doesn't exist, we want to go to 97. But why shouldn't we be considering all three of those possibilities?
Third option, Your Honor, is a repugnancy, and that is the result of last resort under our case law. That's the Hansen case and the Roberts case. There is evidence, and the court can consider extrinsic evidence when we have a latent ambiguity, which is when the clause as applied has some sort of ambiguity. So there's not one, but there are two types of typographical errors in that particular provision. Burmeister is also misspelled, okay? When we look at the context of the estate, the report and inventory is part of this. The land at issue is all owned in Kossuth County. So this would logically exclude land in other counties. We also know that all of the land at issue is in this township 97, and there is no existing 92. There's no dispute on that. The court didn't dispute that, and I don't think any of the parties gave serious dispute to that. So the court, that's why the district court was correct in concluding with the evidence before it, looking at the will, having the probate file. I think you can get it from the four corners of the will, but certainly the extrinsic evidence of this patent ambiguity supports the same conclusion, that is Township 97. And then when we go to that, what we have is a general bequest of the land in Township 97, Section 10, versus the very specific legally described bequests to the others. The harmonization comes from each party gets the specifically devised bequests. The general bequest would apply to any other undescribed land, which certainly includes this after acquired property. We avoid the repugnancy. We give voice to Art Kahler's wishes, which is clearly that the Burmeisters have any additional land in that section, township, and range.
And the Burmeisters receiving more acres than the other families?
Slightly more. So what we have are some individuals getting about 40 per person, some 45 per person. Here, the Burmeisters would get 50 per person. This is not violative of, I think, the sense of fairness, but we also don't have in the four corners of the will that Art Kahler necessarily wanted each individual to have the same amount of land. But what we can infer is that he wanted, if anything, the Burmeisters to have more because, again, we have this clause that gives additional land in the same section, township, and range to the Burmeisters.
Thank you, Counsel, and you'll have more time on rebuttal.
Thank you. May it please the court, Mr. Smith, on behalf of myself and Mr. Mulholland, we're here on behalf of the estate to address what I think is a fairly simple legal issue. And it boils down to this, and that is, should a will be interpreted and enforced as it is written? And that's what the district court chose to do. What we're asking you to do is follow that same basic legal principle that is, I don't want to say written in stone, but it is well established that that is the ultimate goal here, is to enforce the will as written if that is possible.
The district court did agree that there, and I think all the parties too, that there was a Scrivener's error, that the 92 should have been 97. So does that make it a little less simple, or?
And I wrestled with that, Your Honor, and we discussed that on the way down here to Des Moines today. And the reality is, what she said was, this is likely a Scrivener's error. But what she ultimately concluded was correcting that Scrivener's error was going to create that patent ambiguity within the will. And she elected then to say, no, I'm going to enforce the will as written. And as written, that phrase referring to Section 92, which I think, as Judge Langholtz pointed out, is down near Humboldt, I believe, in Humboldt County, that becomes a nullity. And then the rest of the will can then be enforced as written. And if you look at, again, what we're supposed to be doing here and what the district court was supposed to be doing, and I believe did, is enforce that will as written if possible. And she did do that. We didn't have to go through all these legal gymnastics that are involved with the construction of a will, because if you just rely on the will as it's written, we get to an ultimate conclusion, because that one sentence is a nullity. That property wasn't owned at the time. That Section 10 property, that after acquired property we're talking about, I think the record is clear that he didn't own any other Section 10 property at the time. If you look at the report and inventory, which is document 56, that lays out all the property that he owned, all the real estate that he owned. And then if you look at the record before the district court, I don't think there was any disagreement or dispute that Mr. Kahler, Art, obtained that property at issue, that after acquired property we're here arguing about, until 2018. So when we look at the report and inventory and compare that to the will, and you get to the will, you find that in, Article 2, he neatly divides up the specific acres that he wants to go to each specific family. And it ultimately results in everybody that's listed there as a beneficiary receiving somewhere between 35 and 45 acres. He does that with the Kolstads in Section A, where he gives a specific description. He does that in Section B, where he takes care of the Burmeisters by giving them land. That's in Section 14. And throughout their brief, there were references to the idea that we're trying to eviscerate Section B of the will, and that's going to be unfair to the Burmeisters. That's not true. What we're suggesting here is that it's that only one sentence in Section B. The Burmeisters are still going to receive this Section 14 land if the will is interpreted as it's written. There's then the Section 23 land that's given to the Leubenthals in Section C. Section D then gives additional land in Section 27 and some additional land in that Section 10 that he did own at that time. And then Section E falls to Charlotte Bonavia, and her land is outside of this particular area, this township. That's why in Exhibit 109 you don't see Charlotte's land. What I want to do and emphasize now is that, and I don't think I did this well enough in my brief, is that if you look at the start of Article 2, it says, "I hereby give, devise, and bequeath my real estate as follows." He is suggesting with that language that he's going to divest himself of the real estate that he now owns. He's not suggesting that there is going to be in some way, shape, or form additional land obtained and that this article is going to dispose of that land. Instead, what you have is you've got Article 4, which is the residuary clause. And that is where any land that isn't specifically referenced in Article 2 is going to fall. There is only one section of property he owned at the time he executed his will that fell into that section. We can all speculate as to why it did. I think there's a fair assumption it's going to be used to pay taxes and expenses of the administration of the estate, but we don't know that. That's not in the record. That's commonly done. But the reality is he identified the land he then owned. He did not.
Section B had properly identified the township, then it couldn't still be a nullity, right? Then there would have to be some kind of determination of his intent, if what you're saying is true, that Article 2 dealt with all the real estate.
I believe that is correct, and we get to the same result. So if we have to resort to looking for the testator's intent, we look at the various things that the court has identified. So we look at the will as a whole. And when you look at the will as a whole, you think, well, wait a second, how could he have intended to give Section 10 land in Section B when he just got rid of Section 10 land in Section A, and he also is going to get rid of Section 10 land in Section D? And the language that's used there, all of my real estate in Section 10, doesn't make any sense if you're thinking that it's only going to be a small portion or it's going to be after acquired property. If that was the case, if that was truly his intent that we're trying to find here, he would have said something like, should I acquire further Section 10 property, or words to that effect. That concept is nowhere found in this will, and we're urging the court to not try to reach outside the will to go look for that intent when it's not necessary. But if you do and say, okay, this is a Scrivener's error, and that 2 should be a 7, we believe that that entire phrase is likely a Scrivener's error because it refers to land that doesn't exist, that could never exist, and that would also be repugnant to what is found in A and D of Article 2.
So just to be clear, then, are you agreeing with the district court that the 92 was likely a Scrivener's error, 97, or are you contesting that it might be a larger Scrivener's error than just that?
Well, I would phrase it this way. I would agree it is likely a Scrivener's error, but the likely Scrivener's error relates to the description of all my real estate in Section 10, Township 92 in Kossuth County, Iowa. I paraphrased slightly there. But I would say that that is the likely Scrivener's error as well, that whole phrase.
That's the numbers.
Correct, rather than just the number. And
Follow your logic about the layout of the will, then when he purchases the after acquired property, then that falls into the residuary clause regardless of the all my real estate in Article 2.
correct, because I believe the district court, no, I don't think.
At that point?
I think, again, we say it's a nullity, and then we say, but if you have to interpret it this way, then you can't reconcile that with Section A and D without exhorting to some, what I call legal gymnastics in terms of the rules of construction. And what we have to do is look for his intent from the will itself. And when you look at the will itself and you look at what he did in his scheme of distribution, how he treated these individual families, and how he, as closely as you could probably do under the circumstances, saw to it that each of these nieces and nephews received, well, excuse me, there were cousins in there as well and non-family members. But each of these beneficiaries received roughly 35 to 45 acres. They were all treated relatively equal. And so when you look at his scheme of distribution, you look at the other factor, which is what were the facts at the time? He didn't own any other Section 10.
Counsel, the district court had before it some exhibits, I'm not sure whether it was your client or some of the other clients that seems to support this. The court found that those were not properly admitted. I don't read you to be sort of contesting that or arguing that we should look to those handwritten notes and those sorts of things. Am I correct in that?
That's correct, Your Honor. I don't think that's necessary. And so, again, without belaboring the point, what we're asking the court to do is go ahead, enforce this will as written, and find in our favor and affirm the district court.
Thank you, Counsel. Reply?
Thank you. The concern with this as-written argument is that it's not going to enforce the will. As written, it would ask this court to exclude about 31 words from the will. And so our case law teaches, of course, that the courts strive to give effect to all provisions. What the appellee calls legal gymnastics is actually something by that definition that our Iowa Supreme Court, I guess, engages in regularly. I would call it harmonization, not legal gymnastics. The Hansen case, for example, involved a bequest of all of the decedent's real property to certain children. It gave a specific option to purchase certain real property to one of those children. Argument was made that those are repugnant. No, that's my land. You don't get to buy my land from me. Court said, no, it's subject to the more specific option to purchase.
About Iowa law, though, that seems to allow only one residuary clause in a will. Does your argument not butt up against that principle?
I don't think so, because there's also, I think, what we can recognize as specific residuary clauses. So I could imagine all of my baseball cards, other than the Mickey Mantle that someone else gets. And if the person buys more baseball cards, it would go to the person that gets all of my other baseball cards. The Mickey Mantle goes to another person. That's classic harmonization between a general and a specific clause. That is not legal gymnastics. We know that Section 22 had land that does go to the residue. Art Kahler did not identify that specific parcel to go to a particular person, so he knew how to not identify parcel, and that could go to the residue and cover costs, et cetera. What we also have here in the four corners is the land to families plan. Now, the district court ruled in favor of the Lubenthal's so that the two surviving members of that Lubenthal class would receive the acreage under that provision, so that a 1/3 part of that provision wouldn't go under the residuary. Now, there was a settlement component to that, but I think the district court was going to land there either way. The district court also correctly found that a curved triangular piece adjacent to the Burmeister property would stay with the Burmeister property even though it was over a section line. That's 2 for 3. The third part here is that this Section 10, Township 97, Range 29 property stays contiguous and in one piece, and it goes to the Burmeisters. That gives meaning to that whole sentence. It doesn't strike it as the option of very last resort. And here, the general and specific can be harmonized. Everyone gets their specific property. Any additional property, which would clearly fit that all my property in that section, would go to the Burmeisters. Art Kahler, it's a short will. He had a lot of land. He was, I think we can, for a savvy enough businessman to survive farming for all these years. And we have to presume he knew what he was signing in there, and that that's what he wanted, and that's why we must strive to give effect to that first. If the court has no other questions, those are the points I wanted to make on rebuttal. Thank you.
To both attorneys for your very helpful briefs and your effective arguments today. We really appreciate it. We will have a written decision in this case forthcoming as soon as we can, and we will now consider it submitted. Thank you.